The cases which I've extracted in the handout are all to do with liability decisions in the past 12 months. Seeing as I am going to have to go at a canter and try and not keep you here too long, I will just touch on some of the principles espoused in the cases and whether it takes us any further. Start with the section on employers' liability. Many of you will be familiar or will have heard of already the case of Reynolds and Strutt and Parker. This was a away day organised for around 30 or so employees of the estate agent Strutt and Parker, in which the final event was a cycle race. In the concluding stages of the cycle race, the claimant, undertaking what all the evidence seemed to suggest was a very aggressive manoeuvre to try and win, suffered catastrophic injuries when he crashed into, out of a field of 12, oddly enough, the only other person wearing a helmet. What the case turned on, or rather the claimant brought a number of claims, common law and also employers' liability regs. Quite surprisingly, it was found that he was not at work or in the course of his employment when attending the away day. I don't think there can be any confusion here that they really were expected to attend on the particular day. It was on a normal working day, and further to that, they were still paid their wages at the time. The judge, His Honour Judge Oliver Jones, stated that it would offend a sense of justness and reasonableness if it was found that he was acting in the course of his employment. The strange thing about the case is that having found that none of the EL regs applied, he then went on to find that on the basis of the employer-employee relationship, they had failed to adequately risk assess it. And therefore found that the partners who organised the whole thing were liable. It is a somewhat strange decision if you read it. The next case on manual handling, it's Gaith and Indesit. All that can really be said about this case is it re-emphasises the fact that a duty to make a risk assessment is separable, wholly separable, from the duties to reduce the risk to the lowest level reasonably practicable. And effectively what happened in this case is the judge looked at two risk assessments that the employer made, said, well, they seem okay to me, no breach. It was rightly pointed out that the duties are separate, and the judge below had not identified the relevant risk. The relevant risk here was that two guys who had been unloading something from 9:30 to 4 in the afternoon without sufficient breaks were probably going to suffer some lower lumbar pressure. I will leave you to read the facts. I've extracted them there. Moving on to PPE. It is the case of Blair and Chief Constable of Sussex. This is to do with someone who was training on motorcycles. He, as part of the exercise, was required to go down off-road tracks. They were deeply rutted. He got thrown off. He suffered an accident. And what he said was, you gave me normal cycling boots. I should have had motocross cycling boots. You may have seen them. They're the ones that come higher up nearer the knee, usually out of some plastic substance. The judge, at first instance, said, well, standing back, looking at all the circumstances of the training exercise, I find that the boots that were given were appropriate. There is no liability attaching. Claimant appealed, pointing out that the judge had conflated two different issues under the PPE regs, and pointing out, as they did appeal, that he'd confused the concept of effectiveness with the concept of appropriateness in assessing liability. The Court of Appeal is very clear on this. You need to approach the question of PPE in a structured basis. Identify the risk, then worry about whether it is effective within the terms of the regs. And if you find that it's not effective, or alternatively, it would have been practicable to make it effective, then you don't even get on to the question of appropriateness. In first instance, the judge had gone to the final stage first. A breach of manual handling regulations arising from lack of refresher training, that's Costa and Imperial Hotels. That really turns on its own facts, and no insult to a member of our venerable chambers who appeared in that case, but I'm going to skip it over. In terms of workplace cases, there's a case Anne Wallace and Glasgow City Council. There's a case relating to ventilation. Effectively, a poor woman tries to air out a loo cubicle that she's just been in, stands on top of the loo breaks, and she brings a claim under the workplace regs. Must have been a very embarrassing situation for her. Nevertheless, when it went up from first instance, at first instance, Lord Tyre effectively said, well, she should have just never tried to stand on the loo. Oddly enough, they didn't think that was an appropriate approach to the burdens of the regulations on appeal. And you can see at paragraph 32 what they said about the risks. It's interesting to note that one of the ways in which he tried to bring the claim was to say that effectively the fact that the loo broke showed that they hadn't been maintaining the workplace. Well, you can see what they thought of that. Commenting at, as I put it, paragraph 33, they say, abuse by the employee of equipment of the purpose for which it was never designed does not establish that equipment was not in an efficient state or not in efficient working order, not in good repair. I'm going to completely pass over the RTA cases, probably being the most fact-specific of all the cases that have been near the Court of Appeal and High Court recently. At 58, my numbering on my pages is different to yours. I've spread it out a bit on mine, so I won't refer you to pages. Section C, which is paragraph starting at 58, I talk about Drysdale and Hedges. It's a case involving DPA, occupiers liability, and the LTA. Again, they're very keen to point out that if you're trying to claim that something is defective, and you're trying to claim the protections of the DPA or the LTA, you must be clear on what represents a defect under the purposes of those regs. In this matter, a poor woman who was going up with her friend trying to lift something up some stairs slips over on a painted step. It was raining at the time, and the type of paint used effectively made that surface very slippery indeed. But there was no want of repair. As the court stated in the case, you can't claim that just by being painted they were in want of repair. If the repair that you're talking about is removing the paint, you can't stretch the language and ambit of the DPA to fit those circumstances. And I think, actually, if you're coming at it from a defendant angle, this is really more of the case law that we've seen with a case like Alker and Collingwood, and Quick and Taff, which are really defendant-friendly authorities on both the DPA and the LTA. How am I doing? I won't go through landlord liability under Hanningdon and Hillingdon, just to note that the argument that was defeated there, which poor old Mo Hack had to submit, was described as totally unrealistic. So that's damning criticism of that particular point he had to run on instructions. I think I'll conclude with just the troika of cases and one to do with welly-wanging that's found at paragraph 67. The case of Cornish Glenroy Blair Ford, good name, and CRS Adventures is the case involving the poor unfortunate teacher who, whilst attempting in a mini Olympics event to throw a rubber welly through his legs, sustained a horrible injury and was, rendered tetraplegic. In respect of the accident itself, it really turns on the claimant saying that this was foreseeable. The people who were running the event had a risk assessment in respect of the events which they were going to run. However, they didn't have any specific risk assessments as to, say, the welly-wagging, or actually, to be more clear, in respect of handicapping the event. Most people were allowed to throw it in a normal way. The adult teacher, the claimant, was told to throw it through his legs backwards, and it was that really forebode ill for him as he tried to throw it in a very particular way to get a particular length of distance. Effectively, in this matter, the courts say no, simply not foreseeable, and they again, it's a continuation of claims under the Compensation Act that we've seen defendants winning and succeeding in cases where there have been very grave injuries, such as Popperwell from last year. Last three cases I want to talk about very, very briefly. Firstly, we have the case of Hammersley Gonzalez, who was a student who got hit in the face by one of his pupil colleagues with a golf club, which the Court of Appeal said that was totally unforeseeable, as there was no allegation about staffing ratios and the ratios were adequate. The claim could not succeed. I add there, out of interest, at the end of those paragraphs covering that case, that there's a case called Fee and Gordon, in which a golfer who accidentally drives his ball and effectively shanks it into the rough and hits the poor claimant in the eye, was found liable for not shouting "for" early enough. The second case, school supervision, is Woodland Swimming Teachers Association. It's a complex case in some cases. The analysis by His Honour Judge Langstaff is, as ever, meticulous and logical in relation to whether someone who is not an employee of a school can owe a non-delegable duty of care. To put it bluntly, His Honour Judge Langstaff says no, they can't. Firstly, because if you're talking in terms of geographical proximity, that would be a strange extension of the common law rules. But further, that if you were going to impose that kind of burden on those who are non-employees of the school, you would in effect be putting the school under a higher burden than the parents themselves would be under. School supervision number 3 is the very, very unfortunate case of Wilkinshire and Fuller. These are the school children who are training for the 10 Tours expedition and get a level of competency so judged by one of the teachers that they're allowed to range out on their own. Whilst doing so, in attempting to cross a ford with some adult assistance by a third party. One of them sadly dies. Now, the claimant failed in that case because she simply couldn't prove, or the estate couldn't prove, that the teacher who was supervising it did not have the requisite skill, experience, to do what he did on the particular day, and indeed he didn't give any instructions which breached his duty of care. Something that you may want to have regard to are the comments by Mr. Justice Owen in that matter, where he talks about the Compensation Act. It's an interesting criticism where he says, in fact, I don't see how the Compensation Act adds anything to the existing common law position, which, if you think about it, is accurate and fair, having regard to all the things that a judge must when considering the duty of care. But interestingly, he says not only does the Compensation Act it adds little or nothing to the common law, he asks why is it enacted, therefore, and when it was enacted, why is it made discretionary in the circumstances? In any event, I, for my part, think that judges like the Compensation Act because it allows them to duck and cover under some kind of statutory shield in these kind of cases. I finished with 2 cases on insurance, one to do with periods of cover under mesothelioma, and the second, the War Boys case, in which, again, insurance cover under RTA principles was considered. I hope that wasn't too garbled and rushed for everyone, trying to get you to the canapes early. Thank you very much.